Sometimes federal district judges have a problem on their hands when they're saddled with the bankruptcy appeal. And here's why. Before the judge was appointed to the federal bench, it's very possible that practicing law, that lawyer, now a judge, may never have had a significant bankruptcy matter. Furthermore, once on the bench, it's very possible, if not likely, that the judge's law clerks never took a bankruptcy course when those law clerks were in law school. So when the bankruptcy appeal lands in the courtroom of the federal district judge, the outcome of that appeal may depend a good deal on the quality of the briefing. And here's where the problem arises. If a party on the appeal is a consumer debtor, it's likely, if not more than likely, that the debtor's lawyer simply cannot afford to put in the $20,000 or $30,000 of time that would be required for a complex, sophisticated bankruptcy appeal. And that, I'm afraid, is what happened a few days ago in the District of New Jersey. A couple filed a Chapter 7 petition, and their lawyer filed the required disclosure saying that the debtor's $3,500 retainer paid not only for the pre-petition services, but also for any adversary proceedings or contested matters that might arise after filing. Well, 2 years later, after filing, the lawyers got the bankruptcy court's permission to withdraw, but by that time, they had run up more than $200,000 in post-petition fees. Here's what the lawyer did. The lawyer filed a lawsuit against the client in a different district based upon diversity of jurisdiction. Well, you know what the debtors did? They ran off to bankruptcy court and said, no, you can't do it. And the bankruptcy judge agreed. The bankruptcy judge said that the lawyer's disclosure said that the $3,500 covered everything, including that $200,000, and therefore ruled that the lawyers couldn't collect or sue for the $200,000. The law firm appealed, and the federal district judge reversed the bankruptcy court, saying that the lawyers had a Seventh Amendment jury trial right to collect their fees. The problem with the district court's opinion is that I think the district judge either misread or didn't read Section 329 of the Bankruptcy Code, which, to my way of thinking, gives the bankruptcy court the authority to review and govern post-petition fees that are to be paid by a Chapter 7 debtor, even if those fees are not to be paid by fee application. As I said, this is one of those situations where you have a pretty sophisticated bankruptcy issue, and it wasn't well briefed on behalf of the debtor. What I hope at this stage is that somebody comes out of the woodwork and volunteers to work for these debtors on an appeal pro bono to the Third Circuit. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. God willing, I will return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, and a very good day.